Good morning. Today we will discuss about one case from the IBC code. This is relating to a question whether the company which is taken off by the ROC, whether that company can be admitted for corporate insolvency resolution process. This is an order passed by the Honorable Enclad Delhi bench that IBC proceedings maintainable even if company's name struck off from the register of companies. What happened in this case is that this is case relating to Electron Shipping Private Limited versus Pierre D. Silva. The respondent, who is an applicant in the NCLT, made an application under Section 9 of the IBC and filed a case against the Electron Shipping Private Limited, which is admitted for adjudication authority for a corporate insolvency resolution process. And it was ordered for further, this is a CRP process, and insolvency professional is appointed. Agreed by this order, this one of the shareholder, that is Electron Shipping Private Limited, Singapore-based shareholder of this company, filed an application appeal before the National Company Law Appellate Tribunal, and argued that once the company is taken off, the case cannot be, the IBC proceedings or CARP cannot be initiated against the struck-off company. The NCLAT rejected his arguments and referred various sections under this Companies Act and upheld the order passed by the Honorable NCLT for admitting the company for CARP process. Let us see what the case is now. Mr. Pierre D. Silva filed an application under Section 9 of the Insolvency and Bankruptcy Code against Ms. Electron Shipping Private Limited, the corporate which was admitted by adjudicating authority, Mumbai bench, by order dated 10th April 2019. The appellant, Electron Shipping Private Limited shareholders, preferred the appeal challenging the order of admission dated 10th April 2019. The learned counsel appearing on behalf of the appellant submitted that name of Mrs. Electron Shipping Private Limited was struck off by the Registrar of Companies on 12th September 2018. In excess of powers conferred by Section 248 of the Companies Act by public notice ROC. Therefore, according to the learned counsel for the appellant, the application under Section 9 of the IB code was not maintainable, and the adjudicating authority erred in admitting the application without considering the status of the corporate debtor as on the date of admission. This is his argument. Just calm down. NCLT relied on after hearing the submissions of both the parties, Honorable Enclad bench relied on its previous judgment in the matter of Hemang Popalia versus the Greater Bombay Cooperative Bank Limited and another to decide the maintainability of the proceeding under the IB code. The bench observed that the Registrar of Companies is empowered under Section 248 of the Act to remove the name of the company from Registrar of Companies. On reading of Section 248 of the Act, Honorable Enclad observed that before passing an order for removing the name from ROC, the registrar must satisfy himself that sufficient provisions have been made for realization of all amount due to the company and for the payment or discharge of its liabilities and obligation within a reasonable time. Further, it was also clarified that, just go one line up, not down. Yes. Clarified that the liability of the persons associated with the management of the company shall continue and could be enforced as if the company had not been dissolved. The appellate bench opined that as per Section 252 of the Act, that is Companies Act, an application against the registrar's decision to remove the name can be made to the NCLT to restore the position of the company and its management before its name was removed. The application under Section 252, subsection 3 of the Act can be filed by the affected company or any of the member or creditor or workman thereof feeling aggrieved by the removal of the name from the ROC. If the tribunal deems it fit, it may direct the company and all other persons to be placed in the same position as closely as possible before the name of the company had been struck off from the ROC. The bench also noted that subsection 7 of Section 248 of the Act clearly provides that the existing liability of the ex-management of the company will continue even after the removal of the company's name from ROC. In view of the observations, Honorable Enquete held that once the NCLT has admitted an application for insolvency proceedings, the position of the corporate debtor company and its ex-management was deemed to have been restored in terms of Section 252 of the Act. So, accordingly, the appeal stands dismissed. So, the company, even it is taken off, its liability does not waived. So, this is the Act. On that day, we missed to discuss about that case, I think so. So, whether we discuss about this case, Bajaj Auto Limited, Ajanta Press and Mechanics Works, others. Yes. In this case, what happened is it has filed an Ajanta Press and Mechanical Works filed, and this is an MSME case. Okay. This is an order passed by the Honorable Supreme Court in 30th of September 2022. Bajaj Auto Limited versus Ajanta Press and Mechanical Works and others. Observation given in this case is MSMED Act Facilitation Council cannot review its own decisions. The Ajanta Press and Mechanical Works filed a claim against Bajaj Auto Limited before the Facilitation Council in the year 2009. The claim was rejected by the council. The Ajanta Press filed an application for reconsideration. The Facilitation Council reviewed its earlier decision and passed an award. Allowing the writ petition filed by Bajaj Auto Limited, High Court set aside both the decisions and remanded the matter back to the Facilitation Council. This is the case. Firstly, they admitted and passed the order, and the aggrieved person has asked for the review, and the review has been done, and agreed by that review, filed an application appeal in the High Court. The High Court has ordered set back both the decisions and remanded once again back to the matter to the MSC Council. So this means that MSME can review its own order. So what happened is, now the matter went to the Apex Court. Apex Court means the Supreme Court. In appeal, the Supreme Court bench noted, after referring to Section 18 and 19, that to begin with, the Facilitation Council should conduct conciliation, that upon failure of conciliation, dispute is to be arbitrated either by the Facilitation Council itself or by an institution to which it is referred, and that the decision arrived at that to constitutes an award. Firstly, that is conciliation. Then conciliation failure means then arbitration, and finally the award has to be given. Come down. Allowing the appeal, the bench allowed the appeal and observed that in this case on hand, the claim of respondent number 1 was stood by the Facilitation Council, rejected by the Facilitation Council by the decision dated 17/2/2009. Since the claim stood rejected, it was like an award, and respondent number 1 ought to have initiated other proceedings to challenge the award. But instead, what he has done they choose to put repeat pressure on the Facilitation Council to review its earlier decision. Unmindful of the fact that they have no such powers, the Facilitation Council reopened its earlier decision and passed the award. The High Court completely overlooked the inherent lack of jurisdiction on part of the Facilitation Council to pass the award, dated 27/1/2016. Come down. So, what happened is they set aside all the awards, because what happened is once the order is passed by the MSC Facilitation Council, it has no powers, it has no revisionary powers. It cannot review its judgment. Okay, whatever award is passed, it has to be only appealable before the concerned commercial courts and to the High Courts and finally to the Supreme Court. So Council has no powers to review its own decision. This is the order passed by the Honorable Supreme Court. This is for today. If you have any doubt, you can ask to me now.
No, sir.
Thank you.
No, sir.
Anybody taking any session today? Any other session?
No. Yes, sir.
Anybody is taking any other session today?
No, sir.
Okay then. Okay, thank you.
Thank you, sir.
Thank you, thank you.
Thank you, sir.
Thank you, sir. Thank you, sir.